Thank you, Major Gruner, for the introduction, and thank you for hosting this morning, and thank you to the Air Force Academy at large. So this has been a project about 2 years in the making. I got started on it, started thinking about it during the space law course at George Washington University back in 2019, and then went through the writing and research and publication process this spring. So I am honored to be able to present the results of this research with each of you and be a part of the discussion. So the goal behind this presentation and the essay on which it's based is to bring an environmental law perspective to recommend solutions to fixing the orbital debris problem. And the basis of my proposal is a Superfund cleanup program for space that's made enforceable through international arbitration. So if you have questions along the way, please feel free to type them into the chat box in Zoom, and then at the end of the presentation, I will take each of your questions in turn. So I must provide the standard disclaimers that the material discussed and presented this morning represents my own personal views and not that of the U.S. government. So here's a roadmap of where we're going to be going this morning. We'll start by discussing orbital debris, why it's a problem, and especially why it's a threat to the DoD mission. We'll look at the current state of law with international treaties, and then we'll get into the proposed legal solutions discussed in the essay. We'll look at the limitations on that proposal, and then talk about some areas for further exploration and research in this area. So first, let's talk about why orbital debris is a problem and why we should care about this issue as space law practitioners. So the first satellite was Sputnik, launched in 1957. So over the last more than 60 years, now we're up to about 7,500 satellites. We, within the past few years, have seen the rollout of CubeSats, which increase access to space at a smaller price. We're seeing efforts such as the Starlink constellation in the process of being launched, which will provide worldwide satellite internet connectivity. And that constellation is going to be about 1,700 satellites. And you can see in the diagram on the right, this is the progression over time of the crowdedness of space. So starting at the top left corner, going down to the bottom right corner is approximately where we are today. And the ring you see in the bottom right corner, that is geostationary equatorial orbit, GEO, which is quite a crowded area, but very important for communications and whatnot, as well as the GPS system. So space is becoming more crowded. We are also becoming more crowded with orbital debris as a result. There have been several high-profile collisions of satellites in space, and between that and just our astronaut activities in general, at this point, we have accumulated about 130 million pieces of orbital debris. And to put it into perspective, low Earth orbit, where a lot of this debris is located, the orbital speeds are about 18,000 miles an hour. So if you think about a collision at 18,000 miles an hour, it doesn't take very much to do a whole lot of damage. So debris hitting a satellite, debris about a centimeter that hits a satellite can cause critical damage to that satellite, put it out of commission. Debris larger than 10 centimeters can completely shatter a satellite or a spacecraft, creating, you guessed it, a cloud of more orbital debris. With our current technology and the Space Force operates the Space Fence, which is a project that's designed to catalog and track all of this orbital debris. Currently, anything smaller than 5 centimeters in size is impossible to track and avoid with our current technology. Bottom left picture you see is a picture taken of damage to a window on the International Space Station. So this rock chip in the windshield, if you will, they think was created by a very, very small paint flake that's flying around in space. So it doesn't take much to do a lot of damage. So you might have recalled in 2007 when China did a test of an anti-satellite mission to shoot down one of their satellites. And so we're going to walk through a visual depiction of the debris field that test has created. So this first picture you see, this is 5 minutes after impact. And now we are looking at 11 months after impact. And in that amount of time, you see just how widely dispersed the trackable debris field from that shooting down that satellite has become. And I do give credit to Major Matt Zellner for borrowing these pictures from a presentation a few months ago. So many thanks for that. So now that we've looked at type of damage that we could be talking about with orbital collisions in space, now we'll talk about why should we care about this. So Donald Kessler, he was a NASA physicist in the 1970s and a very forward-leaning thinker, came up with a concept that we call the Kessler syndrome. And essentially, it looks at the exponential rate of growth of satellites in space, creating exponentially greater risk of collision in space, which then creates debris clouds. Debris clouds create more debris clouds as satellites go through them and get ripped to shreds. And the danger that Don Kessler saw is that if this keeps on unchecked, we create debris, which then creates further debris. At a certain point, it's no longer viable to operate satellites in certain regions of space because of the density of orbital debris and the risk of collision. And so if you can't operate in a certain place in orbit, well, that creates denial of access to that part of the space domain. If it gets bad enough, the entirety of access to space could be lost. So we have very grave threats to mission based on our reliance on satellite technology. So we would lose access to global communications, positioning, navigation, timing, surveillance, and other functions that are a necessity to carry out our mission. Additionally, there would also be grave threats to our way of life in modern civil society. Again, losing access to global communications, GPS navigation, weather forecasting tools, global finance and commercial transactions, as well as government operations. So essentially, if we lose access to the space domain because of orbital debris, as expressed in the Kessler syndrome, we end up with an apocalyptic scenario that could persist for millennia. So there's a lot of need to address this area. So that's the bad news. The good news is there are some technical solutions that are coming out. So in 2018, the University of Surrey in the UK demonstrated the removed debris satellite that was launched from the International Space Station and successfully demonstrated that space debris could be captured with a net. And so on the slide here, you have 3 different commercial options that are in various stages of development that could tackle the problem of orbital debris. So on the left, we have the European Space Agency's effort called Clear Space 1. This is a satellite inspired by a jellyfish. It captures debris with the 4 arms, brings it down to low or into the upper atmosphere to burn up and disintegrate, thus removing the problem of that defunct satellite creating orbital debris. In the middle, this is Oscar. So a university in New York is developing a satellite network that could use nets and tethers to capture debris. The idea is that each satellite could capture up to 4 pieces of debris, bring it down into the atmosphere to burn up. And then on the right is the terminator tape concept. And terminator tape would be attached to satellites before they're launched. And the idea is once the satellite no longer is operational, this sail or this tape will deploy from the satellite. It creates drag, slows it down so it falls out of orbit to burn up in the atmosphere. So, and these are just 3 of several concepts that are under development in the commercial sector. So the good news is we are on the cusp of being able to address this issue. Clear Space 1, I note, is set for its first run in 2025. So hopefully by the end of the decade, we should have several of these kinds of satellites in orbit to help ease the problem of orbital debris. So now that we've looked at the technical solutions, we're going to look at the current legal framework, and then we'll move into how the law should evolve along with the technology to address this problem. So we have to start with the Outer Space Treaty. The Outer Space Treaty is considered the bedrock of space law. The treaty was formed in 1967, so over 50 years old. It's been accepted by 133 nations. The Outer Space Treaty, of course, was developed when there were very few satellites in space, and the main mission as well was getting to the moon. And so this was developed before commercialization of space, where it was really only government actors had satellites and had access to space. The Outer Space Treaty represents a compromise between the US and the Soviet Union regarding participation and the nation's responsibility for private actors in space. So Article 9, we're looking at ensuring due regard for the corresponding interests of other party nations and conducting, using space for peaceful purposes, conducting exploration of space to avoid harmful contamination. So this is aspirational language. It lacks an enforcement mechanism in and of itself. It essentially provides if you have a problem with what someone else is doing in space, go and consult. Article 8 is the first expression of a liability standard for conduct in space. And this applies, it essentially sets a reasonable care standard, and it applies to any nation launching or procuring the launch of space objects, essentially satellites and launch vehicles. And any person in the liability definition can include corporate entities as well as member nations. So what happens if you have a violation of the Outer Space Treaty? Well, violations of treaties are heard by the International Court of Justice. And so the International Court of Justice will hear a case, will render a decision. Enforcement lies with the UN Security Council. In the history of the International Court of Justice, the National Security Council has only enforced a decision one time. The other barrier to enforcement is that if you try to enforce a decision against a permanent member of the UN Security Council with veto power, such as the US, Russia, China, France, for instance, all of whom are major spacefaring powers, such a decision is going to fail. So essentially, we don't have a adjudication or enforcement mechanism to the Outer Space Treaty. We're reliant on the good faith of others, which you can trust some actors more than others. So that's the problem with the current state of the Outer Space Treaty. So the Outer Space Treaty sets the first expression of a liability standard for conduct in space. So in 1972, the Liability Convention was developed, and this has been accepted by 121 nations. So the Liability Convention carved out two different standards of liability. So if you have a space object that lands on the Earth and causes damage, it's absolute strict liability for that damage. However, if you have a collision in space, you go to a tort negligence standard. So you have the potential, and then because we have so many different nations which apply a different legal framework to tort negligence. If you have a case involving a country that uses the common law heritage and the common law standard of negligence versus a country that follows the continental civil law tort standards, you could end up with a different result, and a case would be presented in a different way. So, for instance, a common law, a court in a common law nation will take its decision on expert testimony, witnesses, where a court in a continental or civil law jurisdiction will stake its decision on the documentary evidence and rely a lot less on any expert witness testimony. Now, in a conference I went to, environmental law conference I went to a couple weeks ago at the European Environmental Law Forum, we did discuss this, and there are fewer differences than there used to be in decisions between the two legal systems. A lot of that probably had to do with the fact that the UK, a common law country, was a member of the EU, but with that no longer being the case, it remains to be seen how the two legal traditions will diverge. So the duty of care, we're still on the slide. The duty of care can be established by the orbital debris mitigation standards. So these are international standards that essentially can be used to establish a standard of practice within the space industry in the event of a collision. However, these orbital debris mitigation standards, unfortunately at this time, are expressly non-binding. So that does present an enforceability issue as to those particular standards. In terms of damages, so the big limitation of the Liability Convention in terms of or looking at trying to assess cost for cleanup of a collision in space. So your damages under the Liability Convention would be compensatory damages. So the cost of the destroyed satellites and loss of use, those sort of things. There would not be liability for the environmental damages resulting from a collision. In essence, the cost to deploy one of these or several of these satellites to clean up the orbital debris would not be recoverable under the Liability Convention's standard. So one issue to look at in the Liability Convention's definition is what exactly is a space object? So Article 1 tells us that a space object would be component parts of a satellite, as well as the launch vehicle or other parts. So the general consensus is that orbital debris created from a satellite or a launch vehicle breakup would be considered space objects. So that's a good thing that the liability convention does. So, we've talked about the liability convention standard of care, looked at the definition of what's covered by space object. So let's talk about the difficulties. And a lot of this comes to, we do have a negligence standard and damages accessible under the liability convention, but good luck trying to enforce it. So Article 22 creates an issue because the remedies under the liability convention only apply to member nations. Well, a lot of our actors in space today are private companies. And so if you have private company satellites collide, the company seeking compensation has to request its national government to assert a claim under the liability convention. And because of globalization, we could have several different companies in several different nations that are involved. So you could have the satellite owner is in one country, the satellite operators in another country. The launch vehicle was developed in a third country, and it was actually launched from a fourth country, and that might apply to both or more satellites involved in such a collision. So under the liability convention, the launching nation is responsible for damages. Well, the launching nation might have been where it was launched, but that country and the businesses in those countries have nothing more to do with the satellite. So you could end up with a situation where somebody is found liable under the liability convention simply because they were the launching nation, but they really had nothing to do with the underlying the circumstances that led to the underlying collision. The liability convention also creates a danger that the party seeking recovery might never be able to actually recover from the true party interest, because if, let's say, liability is assessed against the launching nation, but the party actually at fault, let's say it's the company operating the satellite at issue that created the collision, if that company doesn't have any assets to speak of it within the launching nation, you might not ever be able to assess liability against the company at issue. And then, okay, so here's probably the biggest problem is that the liability convention actually does not have a means to enforce liability. So under Article 24, or excuse me, Article 14, you convene a claims commission, and the claims commission can make a recommendation of an award, but the claims commission decision is not binding on parties unless they have expressly agreed for that to be the case. So liability convention is helpful in that it provides us a standard of care and good definitions to work from. However, at the end of the day, you have trouble trying to hold liable the parties at issue in a collision, and there's no method to actually enforce liability. So that brings us to customary international law. Customary international law essentially allows us to enforce international customs against nations in the absence of a treaty that covers the particular subject. So you have to have two elements to establish customary international law. So you have to have state practice, meaning that countries around the world are following the particular custom, and there has to be opinio juris, which is the body of law that confirms the practice. So you might look to domestic law, you might look to trade agreements or those sort of things, and you use induction, deduction, and assertion to establish if there is a body of law that confirms the practice. So what we currently have now that would be on point are the orbital debris mitigation standards developed by the UN Office of Outer Space Affairs. The problem that we discussed earlier is that they are expressly non-binding. So while there likely is widespread adoption and potentially compliance, there's no legal enforcement. So essentially, we don't have a body of law to confirm orbital debris mitigation standards at this time. So from a customary international law perspective, the closest thing that we currently would have would be the precautionary principle. And this is an environmental law principle that nations should avoid taking actions that could result in environmental harm without balancing the risks of harm against the benefits of the action and adopting mitigation standards, mitigation measures. So to the extent that someone's being reckless in space and is not balancing the risk of harm that could result from their activities, they may violate the precautionary principle, but that would be about it. So now that we've looked at the current state of law and its shortcomings, let's look at some proposed solutions. So we'll look at these proposed solutions under the lens of what we are trying to do is to hold actors in space liable for environmental cleanup of the space environment that's necessary from collisions and defunct satellites and the like. So the first prong of the proposed solution I term the Superfund statute for space. So first, let's look at the United States Superfund statute. So the long name for this is the Comprehensive Environmental Response Compensation Liability Act, or CERCLA, as practitioners tend to call it. So what CERCLA does is it allows the federal government to orchestrate cleanup response to industrial contamination up front and sort out liability amongst potentially responsible parties on the back end. So the Superfund is a trust fund that was created by the federal government. It was initially funded through taxes on petroleum and chemical industries, who are probably your most likely parties to creating industrial contamination. And so response costs to clean up are spent from the trust fund, and then the parties are held liable for the cost of responding to the contamination while everything is going on or after the cleanup has already occurred. So one of the nice things about the Superfund statute is that it creates a wide net for potentially responsible parties, and liability is strict liability. So in terms of your broad definition of liable parties, could be any owner or operator of an industrial site, any hazardous substance disposal facility that worked with that site, any arrangers, basically companies that contract for disposal of hazardous waste, as well as the transporters of hazardous waste. So you have a broad net of potentially responsible parties, and then between those parties, it's joint and several liability. So essentially, the government will assess a claim against all of the potentially responsible parties. It's amongst those parties to sort out for themselves who is responsible for what cost. Liability under CERCLA is retroactive, meaning that if industrial contamination was created before the enactment of the statute, parties are still liable for the cleanup from that contamination, even if it was from, let's say, the 1940s or 50s. So some common criticisms of the Superfund statute. Some commentators find that the strict liability standard is too harsh. You run the risk of innocent parties expending large sums on legal fees to escape the joint and several liability, because essentially it's on a potentially responsible party to prove that they did not have anything to do with the contamination. Another issue with the Superfund statute, and it's just the nature of the beast of dealing with industrial contamination, is that such contamination may not be apparent for decades. And within the Department of the Air Force, we often see this where, we're cleaning up, our restoration program is cleaning up contamination at Air Force bases that could have happened many decades ago, or has been building and building over the course of many years. The most recent issue that you may have heard of is the PFOS and PFOA contamination that creates problems if it gets into groundwater sources. So it's happened over many years, and so restoration is looking at something on the back end where, because it happened so long ago, sometimes it's difficult to know who's actually at fault. So applying or looking at these drawbacks with regards to a Superfund program for space, we would have fewer of these issues presented in space. So we have, the technology is improving to track orbital debris, so it would be more readily apparent who's at fault in the event of a potential collision, or at least who the parties to such a collision are. And the hazard presented by collisions is readily apparent and traceable to a particular event where industrial contamination just happens over the course of many years and decades. So those are the drawbacks of CERCLA, but also how applying it in a space context would minimize those drawbacks. So how would this look with regards to orbital debris remediation? So the Superfund analog for space would permit recovery of the cost incurred for environmental cleanup and debris remediation following collisions in space. So where the liability convention limits damages to compensatory damages, environmental liability under a Superfund type statute would enable recovery of those environmental cleanup costs. For instance, the use of the satellites that we looked at under the technical solutions section. And if you are imposing not only liability for the damages caused to another party's satellite, but as well as the environmental liability for the entire cleanup, this encourages responsible use in space. Additionally, it would encourage satellite operators to purchase more insurance to limit their risk. So in Superfund, the way that industrial sites limit their liability under CERCLA is to purchase insurance. This would encourage the same for space activities. So the current insurance requirements under U.S. domestic law are that you have to insure a satellite for 30 days post-launch. If you have a Superfund-like program in place, it would encourage satellite owners and operators to insure for the entire life cycle of a satellite. And so you have, you're spreading out the risk over a longer time, or you're spreading out your coverage over a longer time to ensure that the risk of the cleanup cost is adequately planned for. So in today's system of globalization, where you have satellite owners and operators in many different countries, and the launch providers in other countries still, the question becomes, if we enact something like this, how do we enforce it against somebody who is in a different country? And so the answer that we see for most industries is international commercial arbitration. And international commercial arbitration really took off in the 1970s with the New York Convention. That's the Convention on Recognition of Foreign Arbitral Awards. And so the convention requires that member nations to enforce an arbitral award against a party in that nation that was rendered by an arbitral forum in another nation. And so you have 166 parties to the New York Convention, which covers developed countries, emerging markets, and even some frontier market countries. So we have worldwide application. And since the 1970s, legal commentators have recommended applying international arbitration to resolve disputes arising in space as well. Now, currently, the plurality of commercial arbitration takes place using English law, and a lot of times the seat of arbitration is in London. The big benefit of arbitration, in addition to the enforceability, the worldwide enforceability, is the flexibility. And so even though the plurality of arbitrations might be seated in London, you can hear the case anywhere in the world that's convenient to the parties and witnesses. And these days with COVID, most arbitrations are even taking place virtually, where the panel doesn't even convene together. You can basically host it over Zoom, like we're doing this morning. Arbitration also provides flexibility of the rules applied to make sure that the rules being used are applicable to the case being heard. Now, the Permanent Court of Arbitration has provided a set of rules that could be adopted in disputes pertaining to outer space activities. And then we have seen some adoption of international arbitration within various space agreements. So the Intelsat Treaty, this treaty governs allotments for satellites within geo orbit, as well as their Earth stations, and it provides for binding arbitration with regards to disputes for compliance with the rules and standards set forth in the allotment approval system. Additionally, the European Space Agency Convention provides for binding arbitration for disputes arising under that convention. So we have seen some adoption of international arbitration in space. It would be good to see adoption with regards to liability and fault for creating orbital debris and collisions in space. So now that we've discussed the proposal, the Superfund-like statute for space paired with enforceability of international arbitration, now we'll talk about how we go about implementing this. So ideally would be on the international stage through a new agreement or a modification of an existing agreement, such as the Liability Convention. Unfortunately, there's not enough appetite in the current environment for the major spacefaring nations to get together and do this. And then even if there were such an appetite, it can be difficult to obtain binding commitments from major parties to such an agreement. And we're seeing, we see this with the Paris Climate Agreement, which represents a compromise where the Paris Climate Agreement requires nations to set nationally determined contributions for greenhouse gas reductions, but there's no mechanism to actually hold anyone accountable for their commitments under the Paris Climate Agreement. So that's probably the sort of product you would get on the international stage if there were such an appetite to address this. So practically speaking, domestic law of a major spacefaring nation would be the most likely approach to implement this proposal. And such a domestic law would require the launching and operating parties that are subject to jurisdiction of that nation to accept international arbitration for collision claims and debris remediation in space. So at least you would have, if that nation's party was at fault, that nation's company would be required to go to arbitration if the other party wanted that. Additionally, such domestic law would require companies to publish their consent to arbitration. So you have essentially that company's half of the arbitration agreement out there. So if you have the first mover as the US, Russia, China, or the EU, this would hopefully create a cascade effect that would lead to widespread adoption. Additionally, if you have a major spacefaring nations enacting this in domestic law, we could create some kind of international custom that could essentially make this enforceable as customary international law as well. So that would be the more practical implementation of this proposal. Next slide. So I recognize that this proposal is simply one proposal out of many, and like any other proposal, there are limitations to this approach. So if you have a liability, environmental liability response scheme, you need it to be paired with mandatory enforcement measures to be truly effective. So for instance, the orbital debris mitigation standards that we currently have are evidence of a standard of care, but they're expressly non-binding. So they're ineffective in that you can't hold anyone to actually meeting those standards. The limitation of mandatory binding arbitration is that you have to have an agreement between the parties to an arbitration in order to mandate arbitration and create an enforceable award. So it can be difficult to impose retroactive liability for parties operating satellites that are currently in space. If you do have such a Superfund scheme, you would be limited to the judicial system to enforce liability, such as how the Superfund statute works for enforcement. However, there are examples of various industries that have developed their own arbitration mechanisms. So as Major Gruner mentioned, I arbitrate cases on behalf of the Financial Industry Regulatory Authority, or FINRA. And so that's an example of the securities industry developing their own arbitration system to resolve disputes within the industry. Maritime salvage is another industry that does this, as well as international sporting events have an arbitration system to resolve disputes. So it's very, very possible for the space industry to come up with some kind of binding arbitration system on their own, apart from government intervention. Likelihood is probably low at this point, however. So one risk or one limitation of this proposal is that even if everything is implemented according to the proposal expressed in the essay, owners and operators could decide that accepting the financial risk of orbital debris cleanup is a better deal for them than actually following the debris mitigation standards. And so they could just accept the risk of potential liability and operate as they've always operated, and just, you know, hope and pray that a collision doesn't occur, but don't actually do anything to prevent one. And then, of course, technology is still developing in this area, so we need the law and the technology to develop at the same time. And so because the technology is still in the development stages, we don't know how effective it will be in actually remediating orbital debris and cleaning up the contamination that we currently have. So from talking with various folks who work in this area, as well as just thinking ahead on some potential areas to explore for future research and to further the discussion in this area. So I discussed with Professor Henry Hertzfeld at George Washington University. He's the space law professor. And so his idea is to make binding arbitration for torts in space a requirement to obtain a launch license, a NOAA license, or a Federal Communications Commission operator's license. And so this would essentially create a broad reach of a binding arbitration system that would cover satellites operated in the U.S. but launched from foreign locations, or satellites operated from foreign countries that are launched in the U.S. Launch licensing requirements would put industry on notice, but it doesn't create an obligation if the U.S. is the only country with this requirement. So it doesn't force it on the international stage, but it kind of would lead the development. Now, once other nations adopt this in their own domestic law, it would effectively create a binding arbitration scheme between countries operating or launching satellites in those nations. Another area to look at under domestic law in the U.S. is the National Environmental Policy Act. So the National Environmental Policy Act requires federal agencies who are taking an action, such as issuing a permit, that could have an impact on the human environment, to analyze the potential environmental effects from such an action. So currently, human environment is a terrestrial concept. However, within the Department of the Air Force and the FAA, when we're analyzing certain actions under NEPA, the National Environmental Policy Act, we look at the effects that such action would have on airspace and civil aviation. So this concept could potentially be extended to human inhabited space, such as the orbital path for the International Space Station, other human occupied spacecraft, or you know, we could even say that space is part of the human environment because it's used by humans to you know, conduct many aspects of daily life. So the mechanism to make such a change would most likely require amendment to NEPA by Congress, but this could be a potential area to explore. On the international stage, as we've discussed, there's no appetite currently to amend you know, the Outer Space Treaty or the Liability Convention, or even to create a orbital debris remediation convention. However, trade agreements could be a potential bilateral or multilateral method to where like-minded nations could get together and create an orbital debris remediation standard and establish international norms and customs. So those are a few ideas for further exploration with regards to orbital debris remediation. So to walk through where we've been, we looked at the problem that if the orbital debris issue remains unchecked, it could have catastrophic consequences because it could deny access to the space domain to carry out our military mission and operations, as well as it can wreak havoc on civil society writ large. The good news is that technology is advancing to tackle the issue. So then we looked at the current state of the law, because the law needs to advance to hold parties liable for creating orbital debris and for the costs of the cleanup now that the technology is getting there. We saw that the current status of space law doesn't adequately address this issue, so we looked at the proposal for creating a Superfund type statute for space and pairing it with the enforceability and flexibility provided by international arbitration. So I want to thank you for dialing in this morning. I hope you found this to be a useful session, and look forward to discussing any questions that you might have. Thank you.
Great. Well, Edwin, thank you so much. That was a wonderful presentation, and we really, really appreciate it. It does look like we have gotten at least one question into the Q&A chat box. Okay. This question is from Mr. Scott Harding. He writes, there is litigation pending in the DC circuit between Viasat and the FCC. Viasat alleges that the FCC permitted SpaceX to place satellites in its Starlink network in low Earth orbit without analysis of the impacts on orbital debris. Succinctly stated, Viasat's asserting that NEPA applies in space and that orbital debris would be a part of that analysis. At least federal agencies are obliged to complete NEPA as it does for major federal actions, like the licensing that FCC did for SpaceX in this case. The DC court may find a way to resolve the case without answering the question as to whether NEPA would apply in space, but this case is definitely one to watch. Do you have any comments on this case based on your research and analysis into this question, sir?
I think it's an interesting case to watch, and I would be curious. I think the court would be hard pressed, given the current language of NEPA, to hold the FCC liable for, or essentially say that the FCC failed to analyze the environmental effects. Keeping in mind that NEPA to this point has been a wholly terrestrial concept, but it's good to see movement in that direction. I mean, if they do come back and say that space is a part of the human environment, which I think would be a reasonable conclusion to make based on the facts that we discussed on a couple of slides ago. So you have humans in space on the International Space Station. You have commercial, recently within the last month or so, we've seen a few commercial human manned flights in space. I think it would be reasonable to say that at least low Earth orbit is part of the human environment. So yeah, we'll watch this case and see what happens. But ultimately, I think it's unlikely that the federal court would say that the FCC failed to adequately conduct NEPA. But I mean, if they do go the other way, it'll have huge ramifications for the way that federal agencies do business, including the Department of the Air Force in our NEPA analysis for launch activities. Good question. Thank you.
Next question is from Seth Dilworth. He says, Edwin, great presentation, helpful information. In your research, have you seen other governments create incentives for orbital debris removal?
I wouldn't say it's incentives for orbital debris removal, but it does seem that there is, like, for instance, the European Space Agency collection, or an agency of the EU funded by member governments. So the Clear Space One project is funded by the ESA. That's probably where we're at now, is the governments are creating incentives for developing the technology. So perhaps once we have a better idea of the ability of the technology to effectively address the problem, maybe we'll see creation of more more incentives to clean up the space environment. And I think too, there may be, so you have the, the carrot and stick approach. So the stick would be in your launch license. You know, to get a launch license or an operator's license, you must do these things. And then the carrot would be, oh, well, we'll give you, a certain amount of money to implement. I don't think we're seeing that at this point, but, if anyone has seen anything like that, I'd be happy to know. Thank you. And glad to see you were on here, Major Dilworth. It's always a pleasure.
Thank you. Major Kisiel, I just have a question as we wait to see if any other questions come on. My understanding is that one of the big problems with debris removal may be the willingness of countries that have space objects on orbit, even if those space objects are defunct, to allow other nations to grab up those objects or that debris or that defunct space object to bring it down. Do you see states having a problem with these sorts of cleanup satellites as potential on-orbit ASAT weapons or things that could be used to steal satellite technology that otherwise wouldn't fall into other countries' hands? Any sort of concerns like that?
I mean, you're probably looking at, some 1970s James Bond movie type scenarios where you have the satellite with the big mouth that comes along and swallows up the smaller satellite. I think there certainly is that risk. Your limitations essentially with, these kind of satellites under development is they're designed to pick up something, bring it into the atmosphere, and it all burns up. So you would essentially have to have some kind of capsule that would capture a satellite and, survive the, transition through the atmosphere, essentially to steal it. Now, you probably could have, other kinds of satellites out there that try to hook on and or that try to intercept the communication between the satellite and the Earth station. But I don't think it would be these kinds of satellites that do that, at least not the ones that we looked at currently. I certainly could see some nefarious actor out there trying to do that, though. So that's definitely an issue to be aware of. And employing something like the Terminator tape on, especially sensitive satellites, so that they, at the end of their useful life, they don't need to become and plucked out of orbit. They can deorbit themselves. That would probably be a wise thing to do, to limit the interactions that our more sensitive satellites would have with these orbital debris cleanup systems. Thank you all for dialing in. I enjoyed discussing this with you, and special thanks to Mr. Miller and the JAOE team. I saw several of you on here. It was a pleasure working with you all in the last assignment, and thank you for supporting my research into this area. And thank you, Major Grunert, for hosting.